There are issues about what the future relationship with that court may be. We are members of that court, and so far as we are members and signatories to international law, I believe the government should abide by international law as well as it abides by its own law.
There's no question of that, Home Secretary. The international law in question is the European Convention on Human Rights. It's been incorporated into our domestic law through the Human Rights Act. On the basis of interpreting that international law, our own highest court has said Qatada can go. The problem is that you are refusing to seek to send him back because you prefer to put yourself down before Strasbourg and have this continuing Craven surrender to the European Court, when our own court says that even under the European Convention he should be sent back, but you refuse to send him back.
Well, if I might remind Mr. Reckless, Chairman, that when he refers to our own highest court having said that Abu Qatada can be deported, that was the House of Lords in 2009.
And you've refused to test it since.
Strasbourg judgments that have come since have changed the background against which we are looking and have changed the interpretation in relation to this Article 6 point. The Strasbourg, as I said, has moved the goalposts, and we have to look, and our domestic courts are now looking at this case against that background rather than against the background of the situation that existed previously. Would I have preferred Abu Qatada to have been deported in 2009? Yes, I would, but he wasn't. And it had, of course, at that stage went further to the European Court. We've since had a number of judgments from the European Court in this case, including this most recent judgment. I believe that the SIAC and the Court of Appeal would have looked at their test against the Strasbourg test and not the House of Lords test.
How do we know? You won't test. You've refused to test it. And again, I ask you, will you not just ask the Supreme Court, in the alternative, it doesn't change or undermine the rest of the legal strategy, would the Supreme Court not consider applying the previous test set by the House of Lords, given that the Strasbourg jurisprudence is something they only need to take account of and is not binding? Why will you not test that, Home Secretary?
Well, as you will know, Mr. Reckless, if we have leave to appeal to the Supreme Court and do appeal to the Supreme Court on this particular judgment that SIAC took, what they will be looking at is the point of law on whether there was an error in a point of law in the original judgment by SIAC. They will not be looking at the whole case and a presentation of the whole case. We will be arguing, as we have done in the Court of Appeal so far, about the way in which the SIAC interpreted and applied the law, and it is only on a point of law of that, as to the original judgment, that the Supreme Court will be able to look at this case.
But finally, Home Secretary, you will not ask them about the error of law in that they applied what Strasbourg had stated rather than what the House of Lords had stated and should have been binding on them. And the only reason they were able to apply that is because you didn't put the contrary case in front of them. Why don't you put that point of law in front of the Supreme Court?
Well, first of all, haven't been, in terms of this particular point of law that you're talking about, it hasn't been to Supreme Court so far. The case hasn't reached the Supreme Court so far. We've sought further leave to appeal through the Court of Appeal. The original case, though, the point is, would SIAC have applied the Strasbourg test, themselves have applied the Strasbourg test? I believe that they would have done. I think the evidence that's come out of SIAC and the Court of Appeal indicates that both of those courts would have applied the principle of the Strasbourg test in looking at this case.
Thank you. Because you accepted it, Home Secretary.
I think
that's why. You didn't put the contrary case before them.
With due respect, Mr. Reckless, I think the judges are capable of knowing what the contrary case might be, and the judge in both cases, I think it is right that they indicated that they believe that the Strasbourg case
not if the case is not before them.
I think perhaps you could consider instructing Mr. Reckless the next time you go before
Mr. Ra.
because these are points I'm sure you want to consider. Michael Ellis and then Nicola Blackwood, then we must move on.
Thank you, Mr. Chairman.
Yeah.
Home Secretary, I think when it comes